You've done the research, you bought the rifle, you're lined up perfectly on your target, and your finger puts initial pressure on the trigger. But right before you fire, a sudden crack from the street startles you, and you drop the weapon. In criminal law, this scenario brings us to attempt. Attempt is an inchoate or incomplete offense. It punishes individuals who try but ultimately fail to commit a substantive crime, whether that failure is due to their own incompetence, sheer luck, or a sudden interruption. Let's map the actions of our shooter, Dave. He researches his target's schedule, buys a rifle, drives to the office, and raises the weapon to aim. But suddenly, a car backfires. Dave flinches. Before he can re-aim, a police officer tackles and arrests him. Criminalizing incomplete acts balances competing priorities. On the utilitarian side, law enforcement needs authority to intervene and prevent harm before someone actually pulls the trigger. On the retributive side, the law punishes individuals who demonstrate a genuine, dangerous commitment to breaking the law, even if external factors stop them. The central challenge of attempt law is pinpointing the exact moment this happens. We must determine precisely when bad thoughts legally transform into punishable actions. To solve that timing problem on a law school exam, systematically apply a 5-step analytical framework. Step 1 requires you to explicitly identify the target crime. Before proving an attempt, you must state the specific substantive offense the defendant intended to commit. Applying this to our hypothetical, Dave's intended target crime is clearly murder. Identifying the target crime is an essential first move because it defines the specific legal elements the prosecution must prove the defendant intended to complete. That brings us to Step 2, mens rea, or the mental state. Attempt is universally recognized as a specific intent crime. The prosecution must prove beyond a reasonable doubt that the defendant had the conscious objective to cause the prohibited result. To be liable for an attempt, the defendant must specifically intend to complete the offense. You cannot logically intend to cause a result recklessly. Acting with extreme recklessness might suffice for depraved heart murder, but is insufficient for attempted murder. Looking at Dave, his specific intent is evident. His meticulous research of Victor's schedule, the purchase of a sniper rifle, and his written plans provide evidence that his objective was Victor's death. Attempt law strictly demands this level of specific intent. Society reserves these significant punishments for conscious malice rather than accidental hazards or careless behavior. This flowchart illustrates Step 3, actus reus. Notice the critical gap between mere preparation and the legal tests for attempt. Defining exactly when a defendant's conduct crosses this threshold is the most heavily litigated element of attempt law. Historically, courts navigated this using traditional common law proximity tests. The philosophy here is objective evidence of dangerousness. Under these tests, liability only attaches when the defendant's actions place them physically or temporally very near to completing the crime. To understand how strict proximity tests can be, look at the 1927 case, People v. Rizzo. Charles Rizzo and his armed accomplices drove around the streets of Manhattan actively searching for a specific payroll carrier they intended to rob. However, police officers noticed their suspicious behavior and arrested them before they ever located their intended victim. The New York Court of Appeals reversed their convictions for attempted robbery. The court reasoned that because the gang never found the target, their actions were not very near to the accomplishment of the crime. Their conduct remained mere preparation. Applying a strict proximity standard to our hypothetical, Dave raising the rifle likely crosses the line. But if the police had intervened slightly earlier, say when he was just sitting in his car parked across the street, he might not have been dangerously close enough to face liability under a Rizzo analysis. While proximity tests are designed to protect citizens from premature state intervention, they force law enforcement to wait until the last possible second. Waiting for a suspect to reach dangerous proximity drastically increases the risk of harm to the public. Dissatisfied with that level of risk, a majority of modern jurisdictions shifted to the Model Penal Code substantial step test. This approach reorients the inquiry. Instead of asking how close the defendant is to final completion, it asks what the defendant has already done to advance their criminal purpose. Under the MPC, an attempt occurs when a person takes a substantial step in a course of conduct planned to culminate in the crime. The key requirement is that the action must be strongly corroborative of the defendant's criminal purpose. The text provides a non-exhaustive list of actions that generally meet this threshold. This includes examples like reconnoitering or casing the contemplated location, and the possession of materials specially designed for unlawful use. Under this standard, Dave's liability attaches much earlier. His reconnaissance of Victor's office and his possession of a sniper rifle while lying in wait serve as substantial steps. They strongly corroborate his lethal intent long before his finger ever touches the trigger. When we compare the two standards on Dave's timeline, the policy shift becomes obvious. The proximity test forces intervention at the extreme right edge. The substantial step test moves the line of legal intervention significantly to the left. Because these tests yield entirely different legal outcomes based on the exact same facts, identifying the governing jurisdictional test is the single most critical factor in your actus reus analysis. But our hypothetical holds a hidden twist. Unbeknownst to Dave, Victor suffered a sudden, fatal heart attack seconds before Dave ever raised the rifle. Dave was aiming at a dead man. This brings us to step 4 in the framework: defenses. Does the physical impossibility of murdering a corpse save Dave from an attempted murder charge? This scenario is called factual impossibility. It occurs when a physical condition, unknown to the defendant, prevents the completion of the crime. The strict legal rule is that factual impossibility is never a defense. We distinguish this from legal impossibility, which is a valid defense. Legal impossibility arises when the intended act, even if completed perfectly, is simply not prohibited by law. Because murdering someone is legally prohibited, Dave's failure is merely factual. His mistaken belief that Victor was alive does not negate his culpability. What about the car backfire? Can Dave argue that by flinching and dropping his aim, he abandoned the crime? Under the MPC, abandonment is only a defense if it represents a genuine, voluntary, and complete renunciation of criminal purpose. It cannot be motivated by unexpected difficulty, a sudden fear of detection, or an involuntary startle response. Dave's reaction fails this test entirely. Defenses to attempt are incredibly narrow. To avoid liability, a defendant must either prove the crime they intended does not legally exist, or demonstrate that they repented of their own free will without any external pressure. Finally, we reach step 5, merger. The merger doctrine dictates that if a defendant successfully completes the target crime, the attempt is absorbed as a lesser-included offense. You cannot be punished for both attempting a murder and succeeding in that exact same murder. In Dave's case, Victor died independently. Dave did not successfully commit the murder himself. Consequently, the attempt does not merge into a completed homicide, and Dave remains fully liable for attempted murder. Mastering the law of attempt means moving sequentially through this framework. You must verify the specific intent to complete the target crime, strictly apply the jurisdictional rules of actus reus, and carefully analyze the precise nature of the failure. That is how you turn a chaotic factual scenario into a structured legal conclusion.